Good afternoon, everyone. Thank you for joining us for our webinar today. We're going to give it just a few minutes, let folks trickle into our virtual meeting space today before we get started. Well, I think we have a good number of folks in our virtual meeting space today, so we'll go ahead and get started. Good afternoon, everyone, and welcome to our webinar today presented by our colleagues at the Immigrant Legal Resource Center. Today's webinar is an orientation to family planning and preparedness plans here with a California lens to it. If we go to the next slide, today's webinar is going to be recorded. You'll receive a copy of today's presentation along with the PowerPoint and several other resources. And it'll be emailed to the one that you provided at registration in the next day or so. Throughout the presentation, please utilize the Q&A button to ask questions throughout the webinar. We have set some time aside at the end of the webinar to answer general questions. If you have something that's very case specific, we might private message you and let you know to connect with one of our immigration attorneys. If you need closed captioning throughout today's presentation, if you hover on the closed captioning icon, either at the top or bottom of your screen, and click that CC, you'll be able to enable closed captioning today. If you have any questions, please use the Q&A tab or drop them into the chat, and we have set some time at the end of today's webinar for that. With that in mind, I'm going to turn it over to our colleagues at the Immigrant Legal Resource Center to get us kicked off. I think, Vero, you're up.
Thank you, Alonso, and thank you all who are joining us today. My name is Veronica Garcia, and I'm a senior staff attorney at the ILRC, and I'm joined today by my colleague, Rachel Prandini, a managing attorney at the ILRC. Next slide. So before we jump into today's presentation, I am going to, for those of you who are not familiar with the Immigrant Legal Resource Center, tell you a bit about our organization. We are a resource center that focuses on three areas of practice, right? We do technical assistance and resources for other immigration attorneys and advocates. We also do community education and resources for community members, and work on law, policy, and changes to kind of help make a more just immigration system. Next slide. So today we're going to be primarily discussing how someone could do a family preparedness plan here in the state of California. What are the options, what we should think about as we're going through family preparedness planning and discussing family preparedness planning with other people. We're going to start today with a quick introduction and overview of what is included and why we're thinking of family preparedness planning in this time. We're then going to go into childcare planning in California and what are the options that someone might have here in California, depending on their specific family needs. And then discuss a bit about what educational rights exist in California and how schools are putting into practice or thinking about what they could put into practice as they're thinking about protecting students and parents. And then lastly, we'll finish up by sharing some tips around how you all could go and do family preparedness plannings with other members, either in your own community, whether it's at a school or in, where you live, to help people, think about this topic and how we could delve through this. And then if time permits, we will open it up to some questions that have come in from the group. Next slide. Okay. And with that, let's go ahead and move into the substance of today's training and going over why it's important to think through family preparedness and what are the different components we should keep in mind when we're thinking about planning. Next slide. Before we jump into that, I want to talk a bit about why people are asking about family preparedness, as many of you probably know and have discussed and thought through. A lot of people right now are worried about ICE enforcement and being detained and separated from their loved ones, right? We know that there is an increased enforcement happening in different locations at different levels to different individuals. And a lot of time people have questions about what is the risk to themselves, to their families, right, to their community members, and what they could do to prepare for if the worst happens, right? If they are detained, if they're separated, if they have to think through what will happen if they are removed from the United States, which would be the bulk of today's presentation. But before we go there, I wanted to think through how do we assess risk for someone, and how do we have this conversation or guide people into thinking about their own risks and things that they could do. So the risk of being detained by ICE will depend on someone's location, where they live, what's happening in that location, and also on the person, right? And what is in their own immigration history, what access to certain resources or benefits they might be able to get right in the immigration system. But generally, right, when we're thinking about assessments around how someone could be arrested, or how ICE is conducting arrests, right? We think about it in two different ways, right? There's a thing called targeted arrest, and then something more of a random arrest, right? So currently, right, we observing targeted arrests in immigration courts, right, at ICE checkpoints, at workplace rates, at criminal state courts, maybe at an interview when someone goes to USCIS, right, because they've applied to a benefit. And these are targeted arrests because immigration knows about the individual, right? So they're either going out to seek that particular individual, or that individual is connecting with the system and their information is already known. We're also seeing now more random arrests in public spaces, right? Or collateral arrests during targeted arrests, where ICE is looking for someone but stops and questions someone else, and the other person share certain information, right? That then they might be arrested, right? We're seeing this at like traffic stops. Maybe there's checkpoints, right? Maybe there's a random workplace raid that happens. And I want to mention that the degree of federal immigration enforcement, that is, the frequency or the visibility of these raids, will vary considerably across the country, right? We've seen higher random arrests or higher presence of immigration enforcement in certain cities compared to others. And it will depend on state and local laws also, and what the political climate and what kind of protections, right? So this is an assessment that someone should go and speak to someone in particular, right? But just when we're thinking about it generally, these are some things to think about. Next slide. We know that in this context, right, when we're thinking about targeted arrests and then more of a random arrest, we do know that certain non-citizens are at higher risk of being detained, such as those who might have a prior deportation order, right? Certain individuals with prior criminal convictions or pending charges, or those without any status and without a pending immigration application, right? And so that's where we're seeing, right, and where people are having questions around how to prepare, how to determine what risk they have. These are just some general notes to keep in mind. I do want to say that this could change in the future, right? This is what we're seeing now. But we know that things are evolving, right? Policy changes, immigration law could change, right? Enforcement trends could change. So it is possible that this might change in the future, how we see the risks and analyze the risk to an individual, depending on their own history, right? So it's really important that people follow either an organization like our own, right, the ILRC, or another organization to get updates around what's happening with trends. Despite this increased immigration enforcement, right, I do want to reiterate that there are certain things that people could do in order to be prepared in case they do encounter ICE. One of the things, right, knowing your rights, doing a family preparedness plan, connecting with an attorney, and we're going to delve into that now in more detail. Next slide. Okay, so what is family preparedness, right? Well, when we're thinking about family preparedness, all right, what we're referring to is the different actions that an individual or a family could take in order to undertake and make a plan to protect themselves from deportation, as well as a plan in place that they could put in case, they are separated and they want their wishes and their desires to be put into play, right? And this is in terms of themselves and also their children, right? So what kind of plan do they want in place in case they do face deportation or in case they are separated. I do want to note that today we're going to talk about it in the context of like an immigrant family, right, or an immigrant that might be at risk of ICE enforcement. But family preparedness planning is something we all could do, right, regardless of our status. And that could be put into play when we're thinking about emergencies that might happen and natural disasters, right? Thinking through how do we organize our own life, right, into documents and a file that someone else could potentially use to help us out, right? When we're thinking about it in this context of immigration, right, we're thinking about what are the certain things and information that you need to get into place in order to create your plan, right? So this includes a component of know your rights, right? It's important that immigrant families know their rights if ICE comes to their door or if they encounter ICE on the street or at a traffic stop, right? So knowing how to respond, what rights they have, how to protect themselves, what information they should or should not share, right? And here we're talking about things like when do you remain silent, right? How do you speak to an attorney? Not to allow ICE into your home if they don't have the judicial warrant, et cetera, right? When we're thinking of family preparedness, we're also thinking about how do you make sure you have all the information in a file that includes what your wishes are, depending on what your options might be, right? So this would include investigating one's immigration options. So if a person is undocumented now, would be a great time for them to meet with a legal service provider, either a nonprofit DOJ accredited rep or an attorney or a private immigration attorney to see if they may be eligible for some path to immigration status, as well to know if this person is potentially able to either get a green card or naturalize or know what options they have if they are detained by immigration. And then third, right, would be the child care planning, which is what we most often associate with family preparedness planning, right? Where we think about making a plan for one's child or children, right, in the event that that parent faces deportation or detention, right? So they're not there, they can't take care of their kid. What's going to happen? Next slide. So as people think through, how they could prepare, the first, important thing to think through is how do we understand the rights that we have and how do we exercise those rights, right? So as a reminder, every person in the United States has certain rights given to us by the Constitution, regardless of immigration status. It doesn't matter if you are a citizen, if you are a legal permanent resident, if you have deferred action for childhood arrivals or DACA, or if you have absolutely no status, you have rights, and these rights apply to all of us. The mere fact that someone is present within the United States gives you these constitutional rights. These rights include the right to remain silent, the right to a legal process, the right to refuse to sign and produce documents, and protection against unlawful searches. We all have the rights, and we all must continue to assert these rights. We know that there's more reports coming out of people saying that, why does it matter? My rights are being violated anyway. We understand that that's happening, but it's really important that people continue to assert their rights because it could help them later on in a case, right? It shows that we are standing strong and, letting ICE agents know that we know our rights and we will continue to assert our rights, right? So that's really important. This is just, a snapshot of our general rights. For those of you who haven't seen a full presentation or are curious to learn more about what this looks like in different scenarios, you could visit our website. We have a recording on a Know Your Rights presentation that delves into these different rights and how people could go about asserting those rights for you. And then also at our website, people could access our red cards, right? It's really important that if people are fearful of speaking up, if they do encounter ICE, that, they could use a red card to show that they are asserting these rights and that they know their rights. And, the red card's a great way to do it. You could also go to our website to access those. Next slide. So, in addition to knowing your rights, the other important aspect of planning is understanding what immigration options you might have. And the way to do this is to seek a legal consultation. We know many people have already spoken to an attorney in the past, or maybe to a DOJ accredited rep in the past, and maybe the conversation ended with come check later, right? If you haven't talked to someone in a long time, I would encourage you to go do it again, right? Things change, facts in the person's case change, maybe something changed in policy or law. So you would want to check that out. When someone goes to a legal consultation, right, it's a great opportunity to understand the particular situation in every case, right? Because every case is unique. You can't go off of what something what your neighbor maybe told you or what your friend told you happened in your case, right? You have to have that individualized conversation. It could also help you identify short and long-term legal options. And once you know these short and long-term legal options, this could become part of your family preparedness planning, right? Because in there, you will be able to add information about what could happen if someone is detained, right? Or what are the desires of someone if someone is detained, or what options they might have if they're in immigration court. It's also a great place to understand individualized risks, right? So we started today's presentation by generally speaking about your risk of ICE enforcement, depending if it's targeted or random, right? When someone goes to a legal consultation, they could understand where they might fall in that risks and what could happen if they do encounter ICE. It's also a good opportunity to understand the risks and benefits of applying for certain options that they might be eligible for and what the process will look like. And then this will help someone make an informed decision, right, about themselves and their family. And also, like I mentioned, create an action plan that they could put into place. Next slide. When someone goes and speaks to someone, right, it's really important to make sure that the legal consultation is done by either an immigration attorney or a DOJ accredited rep. It's important to remind everyone that they should be aware of fraud, right? Unfortunately, there's a lot of fraud sometimes when it comes to seeking immigration advice. And people sometimes go to individuals that aren't able to give legal advice, right? So just remind your family members or friends if they are seeking to go to a trusted legal service provider. I know that the colleges have give access to some of this, right? So that would be a great place to start. If not, the screen has a link to an immigration advocates legal directory that someone could go and put in their zip code and then get a list of trusted organizations that they could talk to. Next slide. Okay, so what about family preparedness in this that we're talking about, right? It's a heavy topic to discuss, right? A lot of people struggle with thinking, how do we have this conversation with someone, right? If we're thinking to family preparedness, or how do we have this conversation with our own families, right? If we're thinking about family preparedness, like I mentioned, right, it's important to remember that family preparedness plan is for everyone, not just immigrant families. And it is a way to ensure that the family's wishes are followed in case the parent is not present due to an emergency, right, or a detention. We understand, right, it's an emotional topic and must be dealt with carefully and must include a lot of communications with all the parties. But it's important to have that. Next slide. As we move into our content today, right, as we talk about the different options that exist, I want to stress how important it is to have this discussion with your family, right? And it's really important to prepare any specific documentation that's needed, right, in order for someone to be able to make sure your wishes, what you wish to happen actually happens. And in order to do this, right, the most important thing when we're thinking about planning is communication. This means talking about the plan with family members. This includes your children, in an age appropriate way. It includes people who might take care of your children if you're not here, your partner, your parents, people that live with you, right? So that everybody's on the same page about what the plan is and what your desires are in case you're not there. And, discussing this plan in detail with the potential caregiver or caregivers, right, to ensure that they are committed to the role they're taking on and understand what the responsibilities are if they are going to take care of your child, depending on the plan that you choose. Next slide. Today, we will cover all of the different options that exist in greater depth, but it's important to keep in mind that, it's a spectrum of options and there's not one size fits all, right? And maybe people will use different pieces of the plan to build a plan that fits for their family, and that's okay. Family must decide what fits best with their wishes, right? For example, would they wish for their children to remain in the US or go with their parents to their home country, right? And any special circumstances, such as a custody dispute or children with significant medical issues, right? All that will inform what kind of plan a family might put in place, right? So it has to be specific to the details of your own case and your own needs. Next slide. All right. So as we take a closer look at some of the options for documents that can be prepared for childcare planning in California, we're going to use this example of Sylvia and Jorge throughout today's presentation as we discuss the different plans. And, we will come back to it because it'll help us identify what the needs are for someone like Sylvia and Jorge, right? And the kids and what they want for those kids, thinking through what plan we might use when we're doing family preparedness. So in this case, right, Sylvia and Jorge live in San Bernardino and have 3 children, Anna, 17, who's undocumented, Maria, 12, who's a US citizen, and Fernando, 9, who's also a US citizen. Jorge has been living in the US for 21 years, and Sylvia has been living in the US for 16 years. Sylvia and Jorge are both undocumented. Sylvia was stopped when she was crossing the border and thinks she received an order of deportation at the time. At that time, Jorge has never had any contact with immigration officials. Next slide. Aware of the assault on immigrants, Sylvia and Jorge are making a plan for their family in case either of them come into contact with Immigration Customs Enforcement or ICE officers. They have an appointment to meet with a nonprofit legal service provider in LA to investigate their immigration options. They also attended a community presentation to learn their rights if ICE comes to their home or stops them on the street or a traffic stop. Next slide. They are most concerned about what will happen to their children if they are deported. Their goals are, 1, to allow Anna to stay in the US to finish high school while living with Jorge's sister Luisa, and 2, to coordinate for Maria and Fernando to travel back to Mexico to be reunited with them. In the interim, they would also stay with Luisa. Luisa is also undocumented, so if she too was unavailable, Anna would stay with her best friend's parents, who are LPRs or lawful permanent residents, and the younger children would temporarily stay with one of Sylvia's employers of 15 years who are US citizens. Their biggest fear is that their children will be taken away by child welfare. Next slide. Okay, so keeping Sylvia and Jorge in mind as we go through these different options, today we're going to discuss the options that exist here in California. And please keep in mind that that this is for California. Things differ from different states. And in California, right, today you could think about either having a verbal agreement, right, or an informal agreement where it's a family agrees that they could take care of your children if you're not there. Maybe it will be written down, right, but there's no formal documents that need to be put into place. If you're thinking of a slightly more formal agreement, maybe a family friend is temporarily housing or caring for a child whose parents have been detained by ICE. Maybe they'll look at a caregiver's authorization affidavit, right, which could be signed and put into place to use at schools to make school-related decisions, right? And maybe you're looking for a more formal option, for example, right? So the parents are planning for their child to stay long-term in the United States with either a maternal aunt or maybe someone else if they are not here. So they are preparing to do a formal guardianship, right, if necessary. So let's look at these options and see what they entail as you're thinking through what best fits for someone. Next slide. So starting with an informal arrangement, right? We refer to it as informal arrangements, since it's an arrangement for a caregiver to care for a child without having any legal rights regarding the care and custody of the child. And just to state it plainly, right, it's okay for a child to live with someone other than their parents without the parents having legal custody without that person having legal custody of them. There may be, practical reasons in certain circumstances why it would be better if the person did have a legal custody or had authorization to make certain decisions, but it's not certainly necessary, right? You could have your child live with someone else if that's what you desire. Next slide. So, what does it look like to make an informal arrangement for care of one's child? This involves, right, identifying a backup caregiver who is willing and able to care for the child if needed. It would be discussing the plan with that backup caretaker or caretakers, right? If you assign more than one person and the child or your children. With the backup caregivers, it would be discussing what your expectations are. So, is it a short-term agreement or a long-term agreement, right? Who will cover expenses for the children? Where do the children go to school? What are their needs? The parent will want to choose someone who they trust to take care of their child. When talking with the children about this, right, in an age-appropriate way, how or what type of conversation you have will depend on how old the child is, right? But it would be important to let them know who would take care of them if the parent was not able to for some reason. And, keeping it simple and direct, right? So, for example, letting them know that if you're not there, grandma will pick them up from school and they will stay with her until, you could come back. The children should know the plan and know the name of the person who will take care of them. If they are old enough, they should also memorize the person's phone number so they could get in contact with them if needed. Even though it's an informal agreement and it could be done verbally, right? Having this conversation with the person, consider putting the plan in writing. This will make sure that all the wishes that someone has are written down and someone could refer to them, right? So even if you're not filling out specific legal documents, right, it's best practice to write it down. For example, right, saying, if I or the child's other parent are unavailable, we plan for our children to live temporarily with their maternal aunt. A parent might also consider writing a letter, right, authorizing the aunt to, be able to make certain medical care decisions if they're unavailable, right? It'd be important to check, right, with different providers to see if this is an acceptable form to do it. But it's possible, right, if that's something that they will accept. Also, make sure that all providers have the information of who this caregiver is, for example, school, daycare, after school, so that people know who is going to pick up the child or not. And then also, it's important to write down, in addition to who will care for the child, what important information the caregiver should keep in mind in order to take care of the child, right? So gather important information around, school phone numbers, doctors, right? Maybe their passport, right? Identification documents so that it's all in one location. Writing down who the teacher is, right? Or who's the point of contact and after school so that the person knows or has an easy way to go and find out this information if they need to refer for it somewhere. And, if the parent takes this more informal approach to childcare planning, their chosen backup caregiver will not have legal rights to make all decisions for the child. They won't have the legal custody of the children, right? The parent maintains all those rights. However, there's nothing, like I mentioned, like unlawful about a child living with someone who doesn't have the legal custody and control of them. In some cases, right, this is all that is needed, and this is what might make sense depending on the wishes that someone has for them. We have some examples of certain forms or templates in our family preparedness plan that people could use as a starting point. So if we go to the next slides, you could see that we have, a list of what important documents might go in there. This might differ depending on what the needs of that individual family is, right? And what the needs of the child might be. But when we're thinking of important documents, like I mentioned, we're thinking about passports, We're thinking about birth certificates, right? Social security, medical information, so that people could have access to that. Next slide. It also has a table that could be used to have all of the child's important information, right? Like their date of birth, the child's cell phone if they have one, the school address, right? The information about the doctor, any medication or medical conditions that they should, be aware of, their after school program, their insurance information. Next slide. It also has a table for emergency numbers and important contact information so that the caretaker could see, who is the point of contact, right? Or other family members that they might need to have numbers for. Next slide. Okay. So with that, I'm going to pass it to Rachel, who's going to walk us through the other options that exist here in California.
Thank you, Vero. So I am going to talk about the caregiver's authorization affidavit as well as guardianships as kind of the next couple of options under California law that are getting slightly more formal. Before I do that, though, I do want to answer a question that came in the Q&A box that I think is really important. So this question is asking if there's any information about what ICE and CBP do when they detain a person with a citizen child. They're asking what are they supposed to do? So there is some information about this. ICE actually has a written policy. It's called the Detained Parents Directive, and I'm happy to send it out in a follow-up to today's training. And under that policy, it does say that a couple things that are relevant. One is that ICE is not supposed to take custody of any children unless they are also arresting them, like, doing an immigration arrest on the child under any circumstances. So, according to their own written policy, they're not supposed to take custody of U.S. citizen children. The policy also provides that parents must be given an opportunity to put alternate care arrangements into place for their children if the parent is being detained or arrested and detained. That's what the policy says. Right now, though, ICE is all over the place in terms of what they're actually doing on the ground. We definitely know that they're not always checking with people to make sure that they, don't have minor children and that they don't need to put plans into place for them before they arrest and detain the adult. So this is something that parents unfortunately have to really advocate for with ICE. And also, it's probably wise for people to have an immigration attorney who they can call who could help them do this advocacy. Just recently, Physicians for Human Rights and the Women's Refugee Commission put out a report that they, based on many interviews that they did with people who had already been deported to Honduras, and they interviewed in many people and in many instances people who had said that ICE did not give them an opportunity to make any plan for their children. So unfortunately, this is an area where like the family's going to need to know that they have to advocate for themselves, and then also hopefully they have an attorney or even just like a friend or advocate who could help them with this if they are arrested by ICE. And then the other thing that's interesting right now is that ICE in the past has always said they won't transport U.S. citizen children with a parent who's being deported because they have no authority to take them into custody and transport them. But we have actually heard of them doing it in certain circumstances. So all that to say, it's very unpredictable how ICE will handle children right now. But there is this written policy, and this is an area that, it's important that we engage in advocacy around, because parents really, really should be given an opportunity to make a plan for their children before they're arrested and detained. And everything that we're talking about today in terms of like taking some time in advance as a family to figure out what do we want, what are our goals as a family, all of this should help. But also people need to know that ICE is not necessarily going to follow their own policies. I think we all know that by now. And so some of this may take additional advocacy by the family or by other support that the family has. Okay. Now that I've addressed that question, I'm going to talk about the California Caregivers Authorization Affidavit. So this is a document that we have in California. This is specific to our state, and it is still, something that you would use in a kind of informal arrangement for care. It doesn't transfer custody of children, but it does provide some limited rights to the caregiver. So the caregiver's authorization affidavit is an informal and simple option to consider here in California. It does not need to be signed by the parents, so this is something that can be filled out after a separating event if necessary. However, for a lot of families, it provides some peace of mind to fill it out ahead of time and just stick it in the file of important documents that Vero was talking about. We do recommend, because it's only signed by the caregiver, not the parent, that the caregiver not sign and date it unless or until they're actually using it. But they could fill out the rest of it now and put it in that file of important documents. Any caretaker who signs it will be allowed to use this form to enroll a child in school. And relative caretakers who are related to the child, which I'll talk more about, will also be able to use the form to consent to medical care, medical, dental, and mental health care for the child, and to receive benefits on behalf of the child if the child is eligible for benefits. But again, it does not change custody of the child. The caregiver's authorization affidavits is designed to be employed in two specific scenarios, with schools and with medical settings. So as pertains to schools, again, as I said, it will allow any caregiver, whether they're related to the child or not, to enroll a child in school. Some limitations here, though, is that it does not address preschools and daycare centers, though we think there are good arguments that those types of care settings should also accept the form. And it doesn't specifically authorize participation in school activities like sports and field trips that, parents have to sign a form consenting to, although we also believe that there's a good argument that it should allow the person to do that if they can use it to enroll the child in school. But it cannot be used to consent to special education, and it also cannot be used to transfer school records. So those things must be done by a parent or a legal guardian. Then the other setting in which the caregiver's authorization affidavit can be used and is helpful is medical settings. And this form provides different authorization depending upon whether the caregiver is a relative, which has a really specific definition that's listed here on the slide, and it's also printed on the back of the form, versus a non-relative caregiver. So you can see the definition of relative here is quite convoluted and legal. My advice, if you're working with a family and the backup caregiver who they've identified, you're not sure if they fit into this definition of a relative or not, is to, just do a Google search for adults who are related by blood, adoption, or affinity within the 5th degree of kinship. And some kind of charts will pop up that will help you figure out, does this person fit into the definition of relative or not? This matters because a relative who signs the caregiver's authorization affidavit can authorize general medical care for the child then, in line with the medical, dental, and mental health care that a legal guardian would be able to authorize. If the form is signed by an unrelated caregiver, let's say the backup caregiver that the family has identified is, a friend from church, but they're totally unrelated to the child, that person can use the form to authorize only school-related medical care. And that means medical treatment that's necessary for school enrollment or participation in school-related extracurricular activities. This includes things like vaccinations, physical exams, and medical exams conducted in school. So kind of much more narrow in terms of what it authorizes that caregiver to consent to, depending upon whether or not they meet the definition of a relative. So this is what the form looks like. It's one page. It's available for free on the California Courts website. Also, in the materials that you'll receive in connection with today's webinar, I've provided a link to a website that has a copy of the caregiver's authorization affidavit in many different languages that hopefully will be helpful, just in terms of, explaining it to families and so they can fully understand what's on the form that they're signing. The form was updated as of January 1st, 2026, and this is what the new form should look like. There's also a copy included in our family preparedness plan in English and Spanish. So you can see it's pretty simple, it's pretty short. I'll say again that the parent does not sign this form. This is meant to be used by the person who's caring for the child, in this kind of emergency event. So just that person fills it out with the minor's information. I'll also note that this form does not need to be notarized. And one of the changes that was made to this form on January 1st of this year, and that was made by the Family Preparedness Plan Act of 2025 that passed in California, is that on the form, you can see it now has a warning to local educational agencies, meaning schools and healthcare service providers, that this form does not need to be notarized and that you don't need a seal or a signature from a court. And that's to respond to an issue that some people were seeing where schools or medical providers were saying, I can't accept this form because it's not notarized, whereas that had never been required by law. So it's now very clear on the form itself. This form is only in effect while the child is actually living with the caregiver. So again, there's no need to prepare it in advance, but if it gives the family some peace of mind to fill it out beforehand, the caregiver could complete it, not dating and signing it, and just put it in the file of important documents in case it's ever needed. One last thing I'll point out about the form is that number 8 on the form you can see requests a California driver's license or identification card number. It now offers also the option as of January 1st to put a government issued consular card number. That was added by the Family Preparedness Plan Act of 2025. The back of the form also, which just has like general information about the form and also has the definition of a relative, it states that if you don't have the information requested in item number 8, you could provide another form of identification, including your Medi-Cal number. Okay, so this is a pretty simple form to fill out, and in certain scenarios, this may be a sufficient tool for the backup caregiver to use if needed. When might using something like the caregiver's authorization affidavit not be sufficient? So this is not an exhaustive list, but I would say anytime there's an ongoing custody dispute in the family or there are prior custody orders with respect to the children, that family should consult with a family law attorney as part of their family preparedness planning. And they may need to do something more formal. If the family has a child who has significant medical needs and they don't have a related caregiver who could care for them, then something like the caregiver's authorization affidavit may not be sufficient, because remember that for a non-relative caregiver, it doesn't allow them to authorize general medical care, only for a related caregiver. And young children for whom the plan would be for them to live long-term with a non-parent, something like the caregiver's authorization affidavit is probably not sufficient. And that's a situation where the family would want to think about guardianship, which we'll talk about next. Because the caregiver's authorization affidavit is great, but it's really meant to be more of like a short-term solution. Okay, so Vero promised that we would come back to this family of Sylvia and Jorge and think about the plans that they're making and how some of these tools might work for them under California law. So let's remember their goals here on the screen. They want to allow their older daughter, Ana, to stay in the United States to finish high school, and they want her to live with Jorge's sister, Luisa, if necessary. And they would want to coordinate for the younger children to travel back to Mexico to be reunited with them if the parents were deported. But in the interim, they would also plan for them to stay with Luisa. So for this family, would it make sense for them to think about using a caregiver's authorization affidavit as part of their family preparedness planning? So I think yes. I think that the caregiver's authorization affidavit could be a great tool for Luisa to use for school and medical related decisions for Anna, who is 17 years old. And because we know she's close to turning 18 when she doesn't need an adult to consent to these decisions for her anyway, it's a relatively short period of time. And because Luisa is related to her, she fits that definition of a relative. She could use the caregiver's authorization affidavit to fully consent to medical care, mental health treatment, and dental care for Anna while she's finishing high school. For the younger children, the caregiver's authorization affidavit could also be a good option for them as well, because the plan is just for them to stay with Luisa temporarily. And again, she's related to them, so she could use it for school, she could use it for medical decisions. I will say, though, that this will not help with coordinating the younger children's travel back to Mexico. Remember, this is a California form that's created just for use with schools and medical providers. It's not going to be respected, for example, by the airline if the caregiver is trying to travel with the U.S. citizen children. So, knowing that the plan that the family has here is for the children to be able to travel back to Mexico to reunite with the parents if they're deported, this family would want to make sure that those younger kids have their U.S. passports, and they would want to do that now while the parents are still here and able to sign the forms and go to the in-person appointments with them and all of that. They would also, in advance, want to check with the consulate to see if the children have dual citizenship. And they may also want to check with the airline that they would intend to fly on, just to ask what kind of authorization does this airline require for the children to travel without their parents, because every airline has different requirements for that. So that may not be something that they can figure out totally in advance, but just something for the family to start thinking about. Okay, and we know this family is so prepared that they also have a backup to their backup plan. And so if Louisa was also unavailable, they have this plan for the older daughter to stay with her best friend's parents and the younger kids to stay with one of Sylvia's employers. So would the caregiver's authorization affidavit be helpful in this context as well? So it could be, right? These backup caregivers could also sign a caregiver's authorization affidavit while these children are living with them temporarily. But just note that it would have a more limited authority and application because the backup caregivers here now are not related to the children. So they would not be able to use it to consent to general medical care, mental health, and dental care. Okay, so thinking of the options for childcare planning as a spectrum under California law, we're going to shift to the formal end of the spectrum and consider guardianships. So what is a guardianship? Guardianships can be slightly different, have slightly different meaning and processes in each state. So what I'm talking about right now is specific to California. In California, a guardianship is traditionally a legal process in which a non-parent files a petition with the probate court to ask for legal custody of a child. And as of January 1st of this year, we now have two options for guardianships that can be used for family preparedness planning in California. We have a traditional guardianship, and we now also have a joint guardianship. And this is pursuant to the Family Preparedness Plan Act of 2025 that I mentioned earlier, AB 495. In a traditional guardianship, once a guardian has been appointed by a California probate court, that person who has been appointed the guardian has full legal and physical custody of the child, meaning they can make decisions on behalf of the child. We think of this as them stepping into the shoes of the parent. They must act in the child's best interest, and they're also fully responsible for the child. In a traditional guardianship, when the guardian is appointed by the court, this does not terminate the parent's parental rights. However, it does suspend them while the guardianship is in place. So parents should be made aware of this. A guardianship will suspend their parental rights while the guardianship is in place. The guardianship changes legal custody of the child while it's in place, and it suspends the parental rights. And traditionally in California, a guardianship stays in place until a child turns 18. There is a possibility of terminating a guardianship earlier, but that's a process with the court that I'll talk more about. So let's contrast the traditional guardianship with the new, as of January 1st, joint guardianship under Probate Code Section 2105G. So this new type of joint guardianship is available if the parent is temporarily unavailable for one of several reasons, now including an immigration-related reason. In a joint guardianship, a parent and a non-parent can share custody of a minor child, and each one will have the ability to make decisions for the child. Of course, if the parent is not available to make decisions for the child because of detention or deportation, the other guardian can make decisions without them as authorized by the court. Some benefits of this new joint guardianship process are First, that if a parent files a petition to terminate the guardianship because it's no longer needed, let's say the parent has now been released from detention and they don't feel that they need this joint guardian over their child, there is a presumption that termination of the guardianship is in the child's best interest, meaning it's likely that the court is going to terminate the guardianship as no longer needed and as being in the child's best interest for the child to just go back to, there being no guardianship in place and them being in the legal custody of their parent. This presumption in favor of terminating a guardianship when a parent requests that it be terminated doesn't exist in a traditional guardianship. So in a traditional guardianship, a parent could file a petition to terminate the guardianship if, let's say, they're available again to take care of their child. But it's up to the judge to decide what is in the child's best interest. And there's no presumption just because the parent is petitioning to terminate it. So that's a big difference between the traditional guardianship and the joint guardianship. Another big difference is that in these new joint guardianships, all records and documents in the proceedings are confidential under state law. Normally, guardianship records in probate court are public records unless they're made confidential by a specific provision of the law. So this is also a significant difference from a traditional guardianship. And again, these new joint guardianships are only possible as of January 1st. So we're just sort of starting to see how these will play out in practice. Some considerations about who could serve as a child's guardian if a guardianship is needed. So first, the person must be over the age of 18. They don't have to have immigration status. Our state laws are very clear on that. They do not need to be a family member, so they can be related to the child or they could be unrelated, just a family friend, a teacher, a coach, anyone who the family feels is appropriate for the child. They do have to be willing to be responsible for the child until the child's 18th birthday. And they should know that they will have to undergo an investigation by the probate court if they're related to the child, or the Department of Children and Family Services if they are not related to the child. A guardian, if they are actually appointed by the court, will remain in place until the minor turns 18 in general. And so people should be aware of that as well. So if a parent wants to plan for their backup caregiver who they've identified to become their child's guardian, if they themselves are detained or deported, what can they do now? There is a form that they can fill out called a nomination of guardianship, where they write down that person's name as the person who they, the parent, nominate to serve as the child's guardian if necessary. And we have a form for this in California. It's called the GC-211, and it's available for free on the California court's website. And it's just a form that the parent could fill out now. They would put the name of the person who they've identified that they would want to serve as the child's guardian if it becomes necessary, and sign the form and put it in their file of important documents. They can make this nomination conditioned upon a future event. So, for example, in many instances, probably in most cases, the parent's only going to want to nominate this person to be their child's guardian if they're actually detained or deported. So they would write that into the nomination. And I'll talk about how to do that next. This form, they can fill it out and just put it in their file of important documents. It doesn't expire. It doesn't need to be filed with the court in advance. And the court wouldn't accept it because this is a form that would only ever get filed if the backup caregiver does need to file for guardianship for the child. It's not something, again, that you put on file with the court in advance. And if a parent fills out this nomination form, the court will then give it due weight when a guardianship petition is filed, meaning the court will look at it and go, okay, this is actually the person that the parent wants to be the child's guardian, and they will give that weight in deciding whether to appoint the guardian. If a family does get to the point where a guardianship is needed or desired, I would just note that many counties have self-help guardianship services in their courthouses or county legal aid offices that can assist with the guardianship filing itself. So nomination of a guardian can be done for a traditional or a joint guardianship, so either type of guardianship that we have now available to us under California law. a parent should know that if they want the backup caregiver to pursue a joint guardianship, they want to say that in the form. So they're nominating this person to serve as their joint guardian. And they also have to list the circumstances in which the nomination of guardianship would go into effect. And they do that just by adding an attachment to the form GC-211. And they could write something like what I have here on the screen, which is pursuant to Probate Code 1502B. This nomination of guardianship shall only take effect upon my detention or removal from the United States. And maybe they would only want it to say one of those, for example. There's nothing magic about the language that I put here. Any way that they can make clear that they're really only nominating this person to serve as the child's guardian if they are detained or deported. If that's what they want. So when might a guardianship be necessary? So as I've been describing, a guardianship is a much more formal arrangement where a probate court, and only a court can appoint a guardian for a child, transfers legal custody of the child from a parent to the guardian. So a guardianship might be necessary for a child who is going to need significant advocacy. For example, a child with significant medical needs. They may, if the parent's unavailable, need someone who has full guardianship of them to be able to navigate all of the medical system for them. A guardianship might be necessary if a parent has been removed and is not going to be reunited with the child for the foreseeable future. This is a longer term approach to put into place, right? Because this is once the court appoints a guardian, it typically stays in place until the child turns 18. So it's not something we want to do for like a short-term solution. If there's a parent who's going to be detained for an extended period, they might consider a joint guardianship because they are detained, and so maybe they're not able to, help their child navigate medical care if that's what the child needs, or if they're getting special educational services or something like that. They may prefer to put a joint guardianship in place so that they maintain their custody, but there's another person who is not detained who's able to help the child navigate those things and who has the authority to do that. A guardianship might also be necessary if a child has expressed a desire to remain in the United States long term and the parents are not available to care for them. A guardianship is not needed when the parent and child are currently together, so no separating event has occurred, or when the parent and child are going to be reunited in the foreseeable future. Remember that a guardianship is a significant kind of legal step to take. So let's think again about Sylvia and Jorge. Would it make sense for them to nominate a guardian for their children as part of their family preparedness planning? And I have, as a reminder, their goals here on the slide again. So for Sylvia and Jorge, it probably is not going to make sense. Anna is so close to turning 18 when guardianships expire by operation of law that it may not be necessary. Also, as we pointed out, because the plan is for her to stay with Luisa, the caregiver's authorization affidavit's probably sufficient because Luisa is a relative of Anna. I will say if Anna was 15 and the plan was for her to stay in the US to finish high school, so she had, years ahead of her, I think the family would want to be thinking about potentially nominating Luisa to serve as Anna's guardian if necessary, because in that case, the family may want to have someone else in the US who has legal custody of Anna and who has authority to make all the decisions that a parent would be able to make for her. For the younger children, because the plan is for them to return to Mexico to be with mom and dad, I would not want to suspend the parental rights by putting a traditional guardianship in place. And it just doesn't seem like a situation where guardianship would be appropriate because really the plan is for them to return to Mexico. And because, again, we know that Luisa is related to them, probably the caregiver's authorization affidavit is sufficient for them to stay with her short term. Okay, so that was our kind of spectrum of options. We have informal plan, family makes a plan, writes it down. This person's going to be the backup caregiver, but they don't fill out any specific forms. Then we have the caregiver's authorization affidavit. It's still informal because it doesn't change custody, but it does give you some rights. And then guardianship, which is the more formal end of the spectrum. That's kind of what we've laid out under California law. Why are we not recommending powers of attorney on that spectrum of options for the specific use of care of minor children? So in California, custody of a minor cannot be transferred from a parent to a non-parent without an order from a judge. And this is different state by state. So you may be aware that in other states, they have something called a short-term guardianship that you can do just by filling out a document. In California, those types of forms do not work to transfer custody, or otherwise authorize a non-parent to make decisions about a child's care, custody, and control. And we want to note that notarizing documents like that doesn't make them any more effective in California. Powers of attorney may be used to designate another person to handle finances, make business decisions, use your money to pay your rent or mortgage, and even use your money to provide for your child. Um, but that's a little bit outside of the realm of what we're talking about today since we're focused on childcare planning. And so there are resources that exist out there on those topics, which are certainly related to care of a child, but just for care of a minor child, we are not recommending that powers of attorney be used in California. Um, it is possible to use a power of attorney, but it needs to be very well written, probably drafted by an attorney, and it needs to follow all of the requirements under California law, and the authorities need to be listed out very specifically. And in California, we can contrast that with the caregiver's authorization affidavit, which is a very simple form that we already have that a family can just simply fill out. And it was created by California law for this specific purpose. It's free and it's also required to be accepted by schools and medical providers, which with a power of attorney that a family, goes and pays an attorney to draft for them, for example, we don't even know if the medical provider or the school is going to accept it. So for all of those reasons, we're not recommending that they be used for care of minor children in California. I am going to stop there, and Vero is going to talk a little bit about some protections that exist for young people in schools in California, and then we should have time to answer questions that are remaining.
Thanks, Rachel. So now we are going to talk about certain protections for children in California, right? So children and youth in schools. Next slide. So as many of you already know, ICE used to have a guideline before that limited immigration enforcement to certain locations, right, known as the Sensitive Locations Memo. These locations included things like churches, schools, hospitals, places of worship, right, where people gathered for protests, areas where children gathered, like playgrounds. And this limited, ICE going, saying they wouldn't do enforcement actions at these certain locations. At the beginning of last year, the Department of Homeland Security announced that they would no longer follow this guideline for sensitive locations. And a lot of people were worried that this meant that they would see an increased enforcement in churches or hospitals or schools, and that people would be fearful about going to these places because they would fear being in a place where ICE might come and do enforcement, right? I do want to note that even though this guideline has been rescinded, right, so it's no longer in place, this does not mean, right, that we have necessarily seen or will see, ICE engage in enforcement actions on school campuses at all times. It just means that they no longer have this internal policy, right? And we know that, like I mentioned, the announcement of this resulted in seeing some enforcement at certain schools, right? We have seen this happen and having an effect on people's attendance, right? And although we are seeing immigration enforcement at schools in certain cities or at certain times, we do not want to point out that we do want to point out that they've mostly done this in like a targeted arrest, right? So going for specific individuals, not doing large scale random arrests, which means that the agents who went to those locations were looking for someone who they already had information about, right? So it's not just randomly going and arresting people. Next slide. And while the Department of Homeland Security no longer has this guideline around sensitive locations memorandum, it's important to know that there are still certain protections for children and youth that exist across the United States, and then certain protections that exist here in California that we should all keep in mind. So first of all, right, under the Constitution, all children in the United States have a right to equal access to free public education, regardless of their immigration status and regardless of the immigration status of the student's parents or guardians. Additionally, the Federal Educational Rights and Privacy Act, which is the federal law, right, prohibits the release of student records and personal information, which we'll cover in more detail in the next slide. Also in California, there are laws that empower schools to welcome all students and reassure them of their educational rights. So in California, all children ages 6 to 18 must be enrolled in school, and all students and staff have the right to attend a safe, secure, and peaceful school, which includes a learning environment free of discrimination, harassment, bullying, violence, and intimidation. And also in California, students have an equal opportunity to participate in any program or activity offered by the school and cannot be discriminated against. And lastly, under California law, local educational agencies like schools are required to adopt model policies limiting assistance with immigration enforcement at public schools to ensure the safety for all California residents, regardless of their immigration status. And under this same law, the Attorney General has mandated was mandated to publish model policies, which he has and have been updated regularly, right? So they are available for people to use as they're thinking through how to create these policies for schools. Next slide. As discussed before, under the Federal Educational Rights and Privacy Act, students' records and personal information is private and cannot be disclosed generally without the written consent of the student's parents if the youth is under 18. However, directory information that is basic student information like honors and awards and dates of attendance, those could be shared without consent of the child's parents. Under California Education Code, the directory information cannot include citizenship status or immigration status. Also, under the California Education Code, local educational agencies have to give notice to students' parents and allow them an opportunity to refuse release of this directory information. FERPA applies to all general inquiries for school records. Also, in a very limited circumstance, records can be disclosed, but only if ICE has a judicial warrant, which is really uncommon. We usually don't see ICE with a judicial warrant when they are trying to access either people or information. Next slide. Last year, many California laws were enacted to protect non-citizens, especially children and youth. I'm going to highlight some of the important new changes according to these new laws. However, I wanted to reiterate that many of these new laws only strengthened what already existed, right? So there were already a lot of protections in California, and these made them stronger. California already had laws that prohibited schools from collecting information or documents regarding citizenship and immigration status, sharing student records, and requiring the Attorney General to develop model policies limiting assistance with immigration enforcement at public schools in accordance with federal law like the Education Code, Section 234.7. Next slide. These new laws put in place certain limitations and requirements, right, when we're thinking about what information can be shared. And these new laws, right, they speak to education facilities at different stages, right? So for example, for licensed child daycare facilities and licensed exempt California preschool program facilities, AB 495, the Family Preparedness Plan Act of 2025 extended protections against immigration enforcement at child daycare facilities and California state preschool program facilities. The law requires that any requests be reported. So any request for information or access to facility by an officer or law enforcement agency is required to follow a parent's instructions for childcare. In case of an emergency, it prohibited from collecting information or documents regarding citizenship or immigration status of children and their family members. And also the Attorney General is required to develop guidance in consultation with appropriate stakeholders, limiting assistance with immigration enforcement for these facilities. Um, the date to do this was April 1st, 2026, yesterday. And all California state preschool facilities are required to adopt them by July 1st of 2026. Additionally, now SB 98 requires elementary, secondary, and post-secondary education entities to also create certain non-notification and safety procedures. So for example, K through 12 district, county office of education, and charter schools are required to create school safety procedures. They have to create these procedures no later than they had to do it no later than March 1st, which already passed, or until the school safety plan is reviewed again until January 1st, 2031. Additionally, for all education entities, including higher education entities like community colleges, they also are required to notify parents, guardians, teachers, administrators, and school colleges personnel of confirmed immigration enforcement presence. They prohibit access to non-public spaces and prohibit information sharing without a judicial warrant, court order, or subpoena. So here you could see that there's a prohibitions are the same as I mentioned before, right, for elementary and secondary school. Just different, now they apply those same prohibitions to post-secondary education, right? And then for notification requirements, it has to consider the safety and well-being of students, employees, and community members of the schools, and requires that there be a hyperlink to resources for families with information about their educational rights, state laws that protect parents and students' privacy and confidentiality. So there's a lot of protections in place, right? The previous slide had the different laws, but these entities should have model policies in place to protect students. Next slide. So now that we've covered that really briefly, we're going to go over how we could share the material that we discussed today, right, on family preparedness. We want to encourage people to help share this information and to present this information to different individuals who might not be present today and might have questions around family preparedness. I will be covering some helpful tips for all of you to consider as we're thinking how to advocate in our communities. Next slide. So why it's important to encourage family preparedness and why to encourage people to complete a plan. There are several reasons, right, that we've discussed to some extent today, right? It's a plan that protects families. It also ensures easy access to important information. And the plan creates clear communication between schools, parents, children, and caregivers. And lastly, it protects parental rights, right? It's important that parents are able to exercise their rights and the wishes for their children. For all these reasons, right, we want families to have a plan in place so that they feel that there's something said in case they can't be there and that their wishes will be respected. Next slide. When conducting a family preparedness training or discussing this or thinking through how we could help people fill one out if we're doing it in a group setting or a workshop, some tips to consider are, when we're discussing family preparedness, we know it's a hard, sensitive subject. We never want to think of this unthinkable thing happening, right, in an emergency, not being there. And we want to be prepared to talk about it, right? So when discussing family preparedness, remind people or folks that before preparing a plan, it is best to first gather the family and talk about why the family is going to prepare this plan so that the family fully understands the reasons and can have a discussion about it. Because of the sensitive nature of these trainings, family preparedness trainings would be best done in smaller group settings or one-on-one, especially if you are walking someone through filling out the plan. If it is possible at all, right, you can coordinate either with a local school or a community center, maybe at a church, right, if we're thinking where we could hold these trainings. And while the training is going, you can encourage families to update their emergency contact information in real time, right? So that they're taking steps to do these things one thing at a time. Some other pointers, right, could include things like printing out the templates or checklists so that they could fill them out as you're discussing them. And you could give them a handout, right? And also a place where they could access maybe the electronic version if they need to print them again. And then additionally, right, you can pair people up so that you could discuss the different components of Know Your Rights, or sorry, family preparedness, which includes to know your rights and getting a consultation and answer any questions that might come up. Be mindful that this could be a lot of information to digest all in one training, right? So maybe it's important to think about it in steps and the different components and how you might tackle that, right? Maybe there's an initial meeting and then a follow-up meeting, right? And maybe you discuss one component of the family preparedness plan, like know your rights, and tell them that next time you're going to go over the child care options that exist in California, so that people are prepared when they come and they're not blindsided by anything and they're not overwhelmed by the information they get. Next slide. Some other things to keep in mind, right? State expectations and takeaways at the beginning, right? So let them know that today we are going to cover this, right? So family preparedness in case the family is disrupted, and what they could expect to take away at the end, right? Let them know that you want to, at the very minimum, identify key topics that you want or you should identify the very minimum key topics that you want the audience to take away. And then you might want to present the presentation to be engaging and see what is needed for the different audiences, right? So when you're having a conversation with parents, right, or if you're thinking of having a conversation with a younger audience, what needs to change? How do you need to present this information? What kind of conversation can you have one-on-one versus in a large group? So just some things to keep in mind. And also it's important to practice, right? I think family preparedness could be a difficult topic, right, to deal with because it's really sensitive, right? So think about what do you need to prepare in order to be able to have those conversations with someone. And maybe if it's not you, you could discuss with someone else how they could have that conversation with an individual or a family member, right? If there's that trust and you're just sharing that information with that point of contact person. And then also make sure that you have the resource materials and referral lists in case people need further considerations. Next slide. And then also, again, remember that there are 3 components of family preparedness, right? There is the child care plan, which we covered today. There's also the know your rights. And lastly, the third component of ensuring that people investigate their options, right? So get that legal consultation. Maybe you won't be the one that takes care of all 3, right? Maybe it'll be a partnership, right? Where someone's doing know your rights, someone's doing child care planning, and then someone's offering immigration options. And like I mentioned, they don't all have to happen at once, right? We could take them one step at a time, but it's important that people understand this so that they could create a plan and be prepared in case they can't be with their family. Next slide. And then just lastly, right, as we're thinking of what to do next after this presentation, right, it's important that we all know our rights and share that information with people, that we encourage everyone to get a legal consultation if needed from a trusted legal service provider to understand their options and how that plays into their planning, that they create a family preparedness plan to protect their family, right, or your family to make sure that things are set, that there's an action plan that could be put in place in case you're not there. And then to stay informed, right? Things are changing really rapidly these days. New announcements of policies have come out, new laws, right, are coming out. So just make sure you stay informed from a trusted source, and that you get your questions answered. So I will leave it there and then see if there's any questions we would want to answer with our remaining time.
Thank you, Vero. Super helpful information that you've shared today. We'll give it a few minutes to see if there's anybody that is interested in dropping a question. I know it's a lot of information, a lot of very heavy information as well. But I don't see any questions in the chat or in the Q&A box coming through. So just given that, I'd like to thank you, Vero and Rachel, for participating today. It was a great conversation, a lot of wonderful information. We will be recording this, or we have recorded this. So you'll be receiving a copy of today's presentation, along with a lot of the resources and information that both Rachel and Beto provided today. And then hopefully we'll be able to share some additional information for those of you that are needing it in Spanish as well. We'll provide some links to some resources in Spanish. So thank you all. We really appreciate your time. Thank you, Rachel and Beto, for the great insights that you provided. Again, we've recorded this and we'll share the recording in the upcoming days.
Yeah, Alonso, if you don't mind, I see someone did ask if we were going to be presenting this information again. We regularly do trainings on family preparedness planning, but for different audiences. But I do just want to point out that on our website, if you go to the page that has our family preparedness plans in English and Spanish, which you will get a link to after today's training, there are recorded webinars, very similar to what you just saw in English and Spanish, that we did live in February. So if you want to rewatch it in English or if you want to watch it in Spanish, those are both there, free access off on our website. So hopefully that's helpful to you.
Thank you for sharing that, Rachel. We'll be sure to include that link in our follow-up email. So thank you everybody for joining us. And again, thank you to our great partners at the Immigrant Legal Resource Center for hosting today's conversation.